Apologise for keeping you all waiting. I had something I had to sort out. I'm sorry about that.
May it please you, my ladies, my lord. Before I get going again properly, 2 minutes. Firstly, when I said this morning in answer to a question raised by my Lord Justice Coulson that the cityscape development was not designed by the defendant in these proceedings, Mr. Hargreaves rightly points out that I'm wrong about that, as it turns out. So, Thorburn Culquhoun was the previous name of URS Corporation Ltd, having been purchased by URS at some point between 2000 and the purposes of...
I'm not sure you're getting that right yet.
It's a name change.
I don't think it goes to the heart of your submissions.
I'm obliged. The second point is perhaps slightly more difficult, which is this. Yes. You may recall when I started this morning, I specifically asked what the court wanted to do about section 135 and the section 135 arguments, and I indicated to the court that they arose on a number of different levels, and the court indicated its preference to have them dealt with at the disposal or handing down, as in not now. My learned friend, Mr. Hargreaves, has asked again that I raise that matter with the court now, and it might be sensible perhaps if Mr. Hargreaves wants to say a few words on that.
Yes, of course. Yes, Mr. Hargreaves.
My ladies and lord, yes, only just to check that there's no confusion and that we aren't all thinking about different things.
Very sensible.
There is a scenario where if my learned friend wins on her negligence appeal, she then has an argument dealing with retrospectivity and the effect of section 135(6) of the Building Safety Act, at which point she submits that the entire action should be struck out and that I should not be able to bring claims under the Defective Premises Act and the Contribution Act. Now, of course, that is naturally an argument that could fall for the decision at disposal, and we're quite happy with that. My learned friend had thought, and I had thought, that that was what was being discussed. However, in relation to the amendments, there are various cases which my learned friend runs against the amendments appeal, for example, under the Defective Premises Act and under the Contribution Act, that the section 1353, the Building Safety Act, which provides that the change to the limitation period under the DPA should be treated as if it had always been enforced. Yes. Those are, my learned friend says, well, that doesn't apply to existing proceedings, and therefore I can't amend to plead the Defective Premises Act or the Contribution Act. And now those, it seems to us, respectfully, are substantive points on the
I think I'm really glad that this has come up, because I can see there's cross wires all round. Yeah. So I see your point there. You're worried about that.
Yes.
In that respect. Yes, that's not your point, or it is your point, or it's a point?
It's sort of, it's a point, obviously, it's a point. My position is
yes.
I think, slightly different.
All right.
Which is this. Mr. Hargreaves is absolutely right, as I explained to your ladyships and my lord this morning. There are different levels at which the BSA arises for consideration. But what the court will be doing is they'll be looking at section 135 and working out how one construes that section as a whole. As in my respectful submission, clearly whilst 1356 will arise for determination, if you're with me on the first appeal, if I can call it that, the way that one goes about construing section 1356 will take its tenor from the remainder of the section, obviously, but also when I come back to my arguments on the Defective Premises Act and the Contribution Act, and the question about the extent to which the retrospectivity provision in section 1353 bites on existing proceedings, assuming for these purposes the negligence appeal is not struck out, again we're back to the same analysis and the same exercise, which is to look at 135 as a whole, and the court is being asked, what is this section as a whole trying to achieve? And in my respectful submission, the difficulty with splitting the argument up, if I can put it in those terms, is you might end up hearing the same things twice, because in order to explain to your lordships what I say, my ladies, I do apologise, my ladies, my lord, what I say the effect of section 135 is, it will require effectively working through the section as a whole, and you will do that again when you come to the 1356 disposal point. So in my respectful submission, one does it once, and either we do it in this hearing or we do it at the disposal hearing, if I can call it like that. But I think there are real difficulties in doing it twice.
Right. Actually, I think we'll just go outside for a moment.
They could, that's
what are you wearing? Suit their hat.
Maybe this is they're thinking that, but without telling us, they're thinking that the retrospectivity under 1353, I'm not sure what an easy point.
Well, I don't. I mean,
that's position C.
I mean, frankly, I don't think it isn't a short or reasonable.
What will they? Well,
you say it is, but obviously you say it is. You say
you
I
wanted
can
them all
read the
determined.
words.
You wanted them all determined by the rules.
Yes, I did. But you have to somebody has to determine them. Williamson knew better than to do that. He was like, if you figure you're going to get me to give the first decision on that, you've got another thing coming.
That's right, that's right.
Yes, Ms. Carton. Well, we're conscious that it's important that we don't get in a terrible muddle and people aren't very sure what they're arguing and what they won't. So I think the sensible thing is for you to put all your arguments in front of us and then we'll dance through them when we come to be considering the outcome of the case.
I'm obliged for that clarification, my lady. effect of what your ladyship has just announced is that although I had thought I might be finished by close of play today, I fear that that is now not going to be the case, and I'm going to trespass on the court's time for some of tomorrow morning. But I will do the best I can to move as quickly as possible through what that means. So before the lunch and adjournment, we were in limb 2 of the negligence appeal, and we were coming to look at co-op and burst, and I had identified for the court that co-op and burst is a very different sort of case to this sort of case.
You didn't take us to the reference.
No, I didn't, my lady. I'm just about to do that for you right now. It is in the core bundle, and it is in the second of the core bundles. And it is tab 24, my lady.
Go on, tab
24.
there in the end. Thank you.
In some ways, we're jumping almost to the end of the what I've called labels broadly to transactional authorities, and we're going to have to come back into the earlier ones. The reason that we have highlighted to the bench co-op and burst up front is that this is with the this and a case called Linklaters and McAlpine, which is behind tab 23, which we will also come to look at later on, are two first instance decisions. Linklaters and McAlpine is a decision of Mr. Justice Aikenhead. And co-op and burst is a decision of Mr. Justice Stuart Smith, as he then was. These are the only authorities which exist in the field within which we are now submitting to the bench, and by which I mean that these are the only two authorities which talk about what one might call third-party claims in the context of a building dispute. Now, both of these cases are very different from the case that's before the court today, for two important reasons. Firstly, both cases concern what might loosely be called a sort of a supply chain dispute, by which I mean main contractor, employer, subcontractor, all involved in essentially the one transaction in the loosest possible word, namely the construction of the one building. The subcontractor in co-op's case, and indeed in Linklater's case, providing a design for the main contractor to incorporate into a building that will be provided to the employer, or, as it transpires in both cases, to someone whom the employer has given a collateral warranty. So we're into the sort of collateral warranty sphere of things. So that is what I might call first distinguishing factor. Our case is not like that. Our case effectively involves Barratt selling on as a professional developer to a number of third parties who are not intimately involved in the transactional chain in the way in which they are in Linklaters and in co-op and burst. So that's the first distinguishing factor. The second distinguishing factor is that in both Linklaters and McAlpine and co-op and burst, the court had before it all of the relevant parties, by which I mean the employer, or the person in the shoes of the employer, had in fact made a claim against the main contractor, and the main contractor was trying to pass it down the chain. So these two cases were what might be called the typical sort of construction dispute. And both cases also concerned claims for contribution made by the main contractor, again passing down the claim which was already before the court to the subcontractors. Now, co-op and linklaters take a very different approach to the question of when a main contractor's cause of action accrues against its designer, when what the main contractor is trying to recover is a claim made up the line. Mr. Justice Aikenhead in Linklaters says the cause of action accrues at the point in time that the main contractor receives the claim from the employer. So at the point in time of the claim up the line being made, then the main contractor's claim down the line accrues. And we'll come to look at how he says that in a moment. He does so relying on a line of authority which involves consideration of a case called NICredit, which is the follow-on case from the Samco line of authority arising out of how the court should treat the fall of the property market in terms of recoverable loss. So we have Mr. Justice Aikenhead relying on NICredit and Law Society and Sefton, which I suspect is a case already known to the bench, in terms of providing for causes of action which involve contingent liabilities not accruing until the contingency eventuates. So you have on the one hand Linklaters, Mr. Justice Aikenhead, NICredit, Sefton, and then on the other hand you have Co-op and Burse following a case called AXA and AXA, I always pronounce this incorrectly, AXA and Derby, which is a decision of this court, a split decision of this court, concerning the entering into of ATE insurance policies and negligent advice given by solicitors in relation to those policies, and in particular when causes of action accrue in those circumstances. AXA, two members of the Court of Appeal holding that they accrue when the ATE insurer enters into the policy. That's Lady Justice Arden and Lord Justice Longmore, and Lloyd Justice Lloyd holding that the cause of action doesn't accrue until the ATE insurer is called to pay out on the policy effectively. Of note, and I put it no higher than this, is that the court gave permission to appeal to the Supreme Court on that case. It appears that the Supreme Court weren't troubled with the matter eventually, I presume because it's settled. But it's quite clear.
Or they refused permission.
Or they, yes. But it's quite clear when you look at the AXA case that it's a difficult case, however which one plays it. So we've got Co-op and Burse, in which Mr. Justice Stuart Smith relies on AXA, and the authorities which are relied upon in AXA itself, which are what I'm calling the transactional authorities, namely Forster and Outred, Ferrier and Moore, and those sorts of cases. Now, in my respectful submission, before we go to look at any of these transactional cases, I say that the court should be distinguishing them when it concerns building cases and that Mr. Justice Stuart Smith erred in this respect in Co-op and Burse, because the transactional cases are concerned leaving aside Carlton Burse, concerned with cases in which an advisor gives some advice and as a result of the advice a transaction is entered into. So to take AXA itself, the solicitors advised that the claims had a 51% chance of success. As a result of that, the policy of AT insurance was issued. To take Forster and Outred, the solicitor advised to enter into the mortgage transaction on the terms that he did. As a result of the advice, she enters into the mortgage. And one can see that same reliance-based approach. Samco and the NICredit case, advice given about the value of the building. As a result of that, funds are lent on the property by the bank. Building cases are very different, and the reason for that you can see very clearly from the facts of this case. This is not a case in which my clients designed a building, and as a result of that design, Mr. Hargreaves' clients entered into a specific transaction with specific features. What's happened here is my clients design a building, it is built, and then BDW goes on to place contracts of sale with third parties in its standard terms of sale form. So there is no feature of the transaction which is affected by whatever it is that my client does or doesn't do. And one can test it in this way. Would anything have changed about the transaction that was entered into but for the design issued by URS? Answer, no, the transaction would have had exactly the same features as it had at the point it was in fact concluded by BDW.
We'll have to look at those authorities, obviously, but that's rather a sophisticated way of looking at the transaction, because in Forster and Outred, and I'll be proved wrong, no doubt, in a few moments, but it's not a case, is it, or maybe it is, of the mortgage would have been different. It was, there would have been no mortgage at all.
Absolutely.
And so so it's not a case of the transaction would have had different bells and whistles if you'd advised me properly. It's I wouldn't have entered the transaction at all. And here it's I wouldn't have built a defective block of flats unless you designed it defectively. Well, so what really is the difference?
Well, the difference is this, my lady, and one can test it like this if one thinks about how one goes. Essentially, one designs the building, and the building is constructed in accordance with the design. At that point in time, of course, nobody knows whether or not the building contains this latent defect.
We're back to the points that we were making this morning.
Absolutely.
Does anything arise until you know about it, or
Absolutely.
does it arise? Is it an exploding tomato?
Yes, exactly.
Yeah.
And that's the point, my lady. We're back to the point that we made this morning about why. Do you remember I said this morning that building cases were different?
And that's what I'm trying to chew and finding difficult.
Yes, and I understand that, my lady. And the reasons that they're difficult are effectively, as Lord Nichols explained in Bank of East Asia, they are different because one is starting with a defect in a physical thing. And so when one starts with a physical thing and one proceeds with it and one transfers it over and over and over again, and no defect ever emerges which affects the property. So if one can test it in these circumstances with these flats, sold in 2004, 2005, I mean, the answer is nobody knows how many times they will have been transacted, but the likelihood is, and again, I don't think there's any dispute about this, the likelihood is that they will have been sold. Many of them will have exchanged hands in the way in which flats in tower blocks do on a number of occasions since the building was first built, and they've been exchanged without any issue arising within them. So it's effectively the ability to transfer the asset.
Yes, and so that those were the points you made this morning, and the only thing that I was taking issue with, I don't want to take any more time, is that whether in fact the transaction cases are your advice led to a transaction which had particular bells and whistles, rather than your advice led to a transaction which I wouldn't have entered into at all if you'd advised me properly. That was the only.
Yes, and my lady, the answer is that the case law makes distinction between those two very, effectively the no transaction and the flawed transaction point. And my lady, we identified the decision, I think, of the Privy Council, the 2020 decision in our skeleton, where one of the members of the Privy Council spells out quite clearly the difference. And of course, the reason for the difference is the difference in terms of the valuation of the loss, effectively.
Yes.
The measure of loss
Yes.
changes. But in my respectful submission, whether one calls it a flawed or a no transaction case, that is not our situation, because the transaction, they were selling the flats. It was as simple as that. And they were selling the flats on the terms that they did. And the difficulty, effectively, is in dealing with what one might call the contingent nature of the defective design and how that affects the transactions themselves. So, essentially, as I say, we say these are very different from the transaction type cases, because regardless as to whether one has a no or flawed transaction point, the point remains that the transaction is the direct result of the advice given, and you can test that by reference to all of the cases that I have just identified. The other difficulty with the co-op and burst analysis, we're about to go and look at co-op and burst now, is that it runs very, very quickly into an approach which is completely contrary to the approach that one is required to adopt by reference to Pirelli, and indeed those other cases that we looked at this morning, in the Cargill, etc., etc. Maybe let's just start with Pirelli, tab 24.
Sorry, with co-op, yes.
Oh, I'm so sorry, my lady. Yes, co-op. Tab 24, supplemental bundle 2, the core authorities bundle 2. Starting perhaps right at the back with the facts, and one needs to find, for those purposes, page 476. There's an assumed statement of facts at Annex A of the judgment right at the bottom, 476 and 477. For current purposes, the following are the relevant dates. The professional retainers, the main contract is February 1998. The contracts with the professionals were March 1998. Practical completion was September 1998. Physical damage was discovered in 2004. That's paragraph 11 on page 477. And proceedings, if one looks at page 478 to 12, proceedings were commenced on the 14th of September 2010. By co-op against the main contractor. That there is some procedural issue with these proceedings here, which, as Miss Justice Stuart Smith makes clear in his judgment, hasn't got any relevance to his findings. But you will see, if one looks down to paragraph 14, there's a slightly odd issue which arises in terms of how time is calculated here. By which I mean it's quite tricky to work out if one takes time, a cause of action being accrued on or before 11th of August and tries to work forward and say when was the claim form issued. Doesn't really make sense. Leaving that to one side, Mr. Justice Stuart Smith starts at paragraph 26 and 27 by saying at the beginning that the first step in the analysis is to identify the risk that the parties owed a duty to protect against. We do place some reliance on those paragraphs for this case.
Sorry, paragraph?
26 and 27. 26 on page 458, what then were the purpose and expectations that underlie the subcontractor's duty to exercise reasonable care? goes on to identify what those are. Effectively, we say yes, and in this case, the same, and indeed in our skeleton submissions at paragraph 16 of our skeleton submissions, you don't need to go there, but just to say that we've replicated that, the Stewart-Smith analysis in our submissions. The reasons for the learned judge's findings start on page 463. He starts at paragraphs 41 and 42 by noting that not all the existence of purely contingent liability will not stop time running, see Sefton. And similarly, the existence of an accrued present liability to a third party is not necessarily actionable damage for the purposes of a claim over against another in negligence. At paragraphs 44 onwards, he deals with the damaged asset rule and the package of rights rule. These are rules which are derived from Lady Justice Arden's decision in AXA, where she distinguishes between damaged assets and damaged rights. Mr. Justice Stewart-Smith starts off by analysing the damaged asset rule deriving from Lady Justice Arden in AXA, pausing there and asking oneself this question: why is a building not a damaged asset for Lady Justice Arden's purposes? One would ordinarily think it would be, but of course, actually, we know with buildings from our counter through the law this morning that when buildings are damaged, on a Pirelli sense, the damage does not accrue until there is physical damage to it. So, at paragraph 46 at the bottom of page 464, Mr. Justice Stewart-Smith says that in this case, Wardley and Sefton are distinguishable on their facts. In each of those cases, there was nothing more than a purely contingent liability, no other financially measurable detriment to the claimant's interests, until, in the case of Wardley, the claimant had proceeded to the fullest extent of its rights against others and made demands on the claimant. Or in the case of Sefton, the misappropriation had not been made good and the client has made a claim in the proper form against the fund. And then he says this: in the present case, there was a present liability which arose at the latest on practical completion, and Burst had suffered measurable financial detriment by then on constructing the development in accordance with the defective design or as allowed by the negligent inspection. Now, pausing there and remembering what it was when Lord Fraser was effectively asked to find the same thing in Pirelli, Lord Fraser concludes that it is not the construction of the building that gives rise to the cause of action, but it is the occurrence of the cracks. So if, as is the case here, Burst had held a proprietary interest in the property at the relevant point in time, the finding which I've just read to the bench would be in direct, it would be completely at cross purposes with what the court held in Pirelli. And the reason that I say that is that in this case, physical damage didn't occur until 2004.
So which is the submission that you rely on for that? Sorry, which is the passage, the sentence?
Sorry, my lord, which
is the sentence that you say would be wrong?
The sentence, in the present case, there was a present liability which arose at the latest on practical completion.
At the very end of paragraph 46, top of page 465.
Yeah. And you say that that would be wrong if what?
That is, if one takes the Pirelli analysis, my lord,
yes,
that sentence is wrong because in this case, physical damage didn't occur until 2004. So the damaged asset rule as formulated by Lady Justice Arden in AXA and applied by Mr Justice Stuart Smith in Cowell and Burst, we say runs contrary to the line of authorities that we were looking at this morning, because it allows for the cause of action to accrue before any damage is suffered to the building at all. He next goes to consider the package of rights rule at paragraphs 48 on through to 55 of this judgment. And the relevant paragraph here is paragraph 53. Where he says, I concluded the present case is within the package of rights rule because when Burst transferred the defective development to the employer, its legal position changed to its financial detriment as it became a contract breaker whose rights under the main contract were devalued by its liability to the employer. And again, we say the same analysis applies. If that is right, in Burst, the cause of action arises at a significantly earlier time than it does if one applies the Pirelli authorities. There's another difficulty with the application of the package of rights rule on the facts of this case. Well, two difficulties, we say. The first is that, as the court knows, no claims have in fact been brought against BDW for breach of contract. So whereas in Co-op and Burst, the court is asked to determine a case in which there is the overriding claim up the line which is before the court, that is not the case here. And we say that means that here there has been no damage to the package of rights. And furthermore, we say that there could be no damage to the package of rights case here when one considers the contracts of sale, because we say that the contracts of sale were all contracts which had a 6-year limitation period attached to them, and the 6-year limitation period expired very, very many years ago. Now, Mr. Justice Fraser did not like that argument very much, and indeed I suspect that I'm about to be faced with exactly the same observation from this bench, which is, well, procedural limitation is a procedural defence, Ms. Parkin, which a claimant can, or sorry, a defendant can or cannot choose to invoke. I would invite this court to consider the observations of a case that we're going to look at again in the context of our retrospectivity arguments, and that is a case called U Bond Chu, which is in our first core bundle behind tab 5. First call authorities bundle by Lady.
Thank you. I'm so sorry.
Sorry, I've lost. Seem to. Problem is, some colour coding would have been bliss. So joint. I can't find
It's
it.
the court joint authority.
I know it's called. I just can't spot it.
Would it help your ladyship if I gave her the non-core bundle reference?
Yes, do please.
Well, that's going to require me to
Which will be-
locate my own.
Nope, found it.
Ah,
Now I've dropped it. Thank you. Now it's
it's tab
Tab.
5, my lady.
tab.
This is about, sorry, tab 5, my
Thank
lady.
you. I do apologise. Thank you.
And we're on here.
Because I'm going to invite the court to see how the Privy Council approaches limitation in the context effectively of the retrospective argument that we'll come to deal with later. But in my respective submission, what is said by the Privy Council is as relevant to the argument that I'm currently making to your lordship as it is to the retrospective.
It was that argument I was trying to.
Oh, I'm so
identify.
sorry. It is the relevance of a limitation period to a package of rights type analysis. So I was explaining to the court how Mr.
Because you don't dissent from the. I mean, you made a proposition, which limitation is a procedural bar.
I said that's what Mr. Justice Fraser had said to me.
But that's right. You don't dissent from that.
I don't dissent
So
from that.
was why I was trying to identify the proposition you were relying on.
Perhaps it's easiest if I just take your lordship to the relevant bit in Ubon 2, in which the court is concerned with with changes to a limitation statute in the context of retrospectivity. It's being asked, are limitation changes procedural, in which case one retrospective consequence flows, or are they substantive, in which case the argument goes another consequence flows. And what the court says in Ubon 2 is that if one looks at page 563, paragraph, letter D, in their lordship's view, an accrued right to plead a time bar, which is acquired after the lapse of the statutory period, is in every sense a right, even though it arises under an act which is procedural. It is a right which is not to be taken away by conferring on the statute a retrospective operation unless such construction is unavoidable. Their lordships see no compelling reason for concluding that the respondents acquired no right. The plain purpose of the Act of 1974, read with the Ordinance of 1948, was to give and not to deprive. And then it says the purpose was not to deprive a potential defendant of a limitation defence which he'd already possessed. The briefest consideration will expose the injustice of the contrary view. When a period of limitations has expired, a potential defendant should be able to assume that he's no longer at risk from a stale claim. He should be able to part with his papers if they exist and discard any proofs of witnesses that have been taken, discharge his solicitor if he has been retained, and order his affairs on the basis that his potential liability has gone. This is the whole purpose of a limitation defence. Now, the reason for taking the court to that passage in that authority is for these purposes. Under the package of rights analysis, what the court is being asked to do is to identify whether there has been a diminution in value of the package of rights itself. In certain of the cases, credit is one example, and Lady Justice Arden and Lloyd Justice Lloyd are prepared to assume for certain purposes that AXA might be another. What the court is asked to do is weigh up the benefits and the burdens of transactions involving rights. So with some transactions come a right, and with other transactions, and then some, so let me start again. Some have benefits and burdens, and it's the weighing up of the two which will lead to the identification of when the loss crystallises. In my respectful submission, where what you're talking about is a limitation defence accruing. If one comes to look at the package of rights and assess what its value is, one has to give weight to that limitation defence. For the sole purpose that if one were valuing the rights at a particular point in time, one would say that once limitation, essentially a certain period of time has expired, a client would not be exposed to what might be called stale claims, if I can put it like that. So we do attach some importance to the expiry of the limitation period for the contractual claims, which my learned friend says are potentially, or he's potentially exposed to under this limb of his cause of action argument.
These would be contractual claims by the purchasers.
By the purchasers.
But there was no assumed fact about limitation.
It is accepted, the assumed fact accepts that no claims have been made and that limitation has expired. In terms of the assumed facts, it had expired for both contractual claims and the claims under
9B.
the DDA. Yes, my lord.
9B.
Yes.
I see. So that's what, this is what 9B goes to.
Well, and other things as well, my lord. But
Yeah. But okay, covered by 9B.
it is indeed partly
Yeah.
covered by 9B. Yes.
Yeah.
Now, Mr. Hargreaves has got some points about 9B being affected by the coming into force of the Building Safety Act, as you know.
Mm-hmm.
The Building Safety Act does not affect those contractual claims. Because they're claims in contract and not claims under the Defective Premises Act.
But could there be claims under the Defective
We're
Premises?
going to come to the Defective Premises Act in a moment. That's why I'm limiting myself at the moment to the contractual analysis.
Okay.
So the Building Safety Act, and this is common ground, does not affect those contractual claims to the extent that any original purchasers still remain in the blocks. Their claims would have long since gone in contract. What then in relation to the Defective Premises Act? Claims under the Defective Premises Act have nothing whatsoever to do with a transaction entered into by BDW. So whereas in Co-op and Burse, what Mr. Justice Stuart Smith was considering was the impact of the defective design on the contractual obligations vis-a-vis the employer, and saying those obligations were damaged. That analysis simply doesn't work for Defective Premises Act claims. And the reason for that is that Defective Premises Act claims are a creature of statute and nothing whatsoever to do with the individual underlying contracts at all.
Except if the purchaser hadn't bought the flat pursuant to the transaction, you wouldn't have a DPA.
Oh, absolutely. DPA claims lie in the hands of the current occupiers of the building, we say.
So you're making a distinction between occupiers and purchasers.
Not necessarily, my lord. I might be, my lord, for this reason. The original purchasers may have long since gone and may have been replaced by, we may be 3 or 4 purchasers down the line. The only people with Defective Premises Act claims, potential Defective Premises Act claims today, are those who live in the flats today. And the only reason that they might have those claims today is because of the Building Safety Act. At the time the matter was before Mr. Justice Fraser, even the purchasers currently in the blocks did not have Defective Premises Act claims because they were subject to the 6-year time limit, 6 years running from the date of practical completion, and practical completion having long since ago happened. So my respectful submission, claims which are gifted to a party under a statute are not claims which fit within the damaged package of rights rule because they've got nothing to do with the package of rights at all. They're instead claims that arise because you happen to live in the property at the point in time that you discover the defect. And we say claims of that nature are claims of a contingent nature as discussed by the House of Lords in Second. Law Society in Sefton is behind tab 19 of Core Bundle of Authorities 1. I hope I can take the facts relatively briefly. The facts of this case arise out of fraudulent behaviour by a solicitor which was not discovered or which was covered up in some accounting reports, the result of which was the Law Society did not act to strike off the solicitor for a considerable period of time after he'd been engaged in the fraud. This led to claims being raised by various clients of the solicitors. The solicitors, the accountants were arguing that the causes of action in those cases arose when the accountants delivered the negligent reports to the Law Society. The Law Society was arguing that causes of action did not begin until claims were made against it under the Solicitor's Compensation Fund, that being a creature of statute set up by the Solicitors Act 1974. The House of Lords held that claims, the causes of action which the Law Society had did not begin to run until claims were made against it. Lord Hoffman's speech, paragraph 9, we place some importance and some significant, we say significant. Damage is an essential element in the cause of action for negligence. Musgrove was negligent when he signed the reports, but the Law Society had no cause of action until it suffered damage in consequence of his negligence. Critical question is when that damage happened. Sefton say the society suffered damage whenever paying misappropriated clients' money after a negligent report had been delivered. Misappropriation gave the client a right to make a claim on the fund, and liability to such a claim was damage. Law Society says it suffered damage only when a claim was made. The misappropriation might have been repaid either out of Mr. Payne's own money or more likely some teaming and lading. The client might not have made a claim. All that could be said was that once there had been a misappropriation, it was likely that there would be a claim, but the Law Society could not have commenced proceedings on the basis that claims were likely. And then over onto page 550 in paragraph 17, I'm so sorry, 549, if I could draw the court's attention to starting paragraph 16, and the reference to the broader interpretation of Forster being rejected by the High Court in Wardley. And page 70, paragraph 17, setting out the decision of the High Court in Wardley, in which the High Court, having been asked to deal with a case concerning the granting of an indemnity on the basis of negligent advice issued, said that the cause of action did not begin to accrue until the indemnity was called upon. Right at the bottom, paragraph 17, Lord Hoffman sets out this quotation: in our opinion, in such case, plaintiff suffers no actual damage until the contingency is fulfilled and the loss becomes actual. Until that happens, the loss is prospective and may never be incurred. I say at once that I'm in complete agreement with this analysis, which provides the answer to this appeal. Until, right at the bottom of 18, until a claim was actually made, no loss or damage was sustained by the fund. I must, however, consider certain other authorities and contrary arguments. And he then goes through the cases, and he returns to his conclusion at paragraph 31, in which he says, Law Society did not enter into any transaction giving rise to the contingent liability. Now, we say that's important in terms of our DPA claims, because the DPA claims are not claims which arise as a result of a transaction. It did nothing, and the contingent liability was created by the misappropriations and the previous existence of the compensation fund and the rules which governed its administration. No doubt, in most cases in which a party incurs a contingent liability as a result of entering into a transaction, that liability will result in damage for the reasons already discussed in relation to bilateral transactions. I would prefer to put my decision on the simple basis that the possibility of an obligation to pay money in future is not itself damage. We say that in relation to the DPA claims, these are claims analogous to the claims under the Solicitor's Compensation Fund, because they depend upon a statutory basis. And until such time as a claim is made under the DPA, the cause of action does not accrue, however likely such a claim might be. So that is how Mr. Justice Stuart Smith dealt with a exposure to third-party claims in Carlton Burse, where, as I say, the claim had actually been made against the main contractor. Returning to how Mr. Justice Aikenhead dealt with it in Linklaters, we need tab 23 of the second core bundle. This is the judgment following on from the trial. There had been a series of preliminary issues before Mr. Justice Aikenhead, one of which concerned whether or not the subcontractors, in this case Southern, owed the M&E main contractors, Howe, a duty of care to guard against exposure effectively to guard against liability to a main contractor. Mr. Justice Aikenhead had found that such a duty existed, and you can see his finding in that respect if you could find, my ladies, my lord, page 256 of this judgment, which is about 2/3 of the way through. And at paragraph 110, under the heading The Law, Liability and the Tort Issues, Mr. Justice Aikenhead notes there were 2 duties of care said to be owed.
So this is all obiter, is it?
Yes, it is, my
I
lord.
confess I've not looked at Linklaters.
It is, my lord, yes, it is.
Because
essentially this is a main trial, and in the trial he found that Southern were not negligent.
Yes.
And he then goes on, as he says, out of deference to the submissions made by counsel, to consider the position if he'd concluded
And in
otherwise.
paragraph 110, he refers to his judgment when he says there was a duty.
He says there was a duty. The scope of the duty is such as to enable Howe to recover from Southern as damages the losses which it's liable to pay McAlpine and to Linklaters in relation to the reasonable costs of putting right negligently executed insulation works carried out by Southern. And then he said, I left over the question of when the cause of action accrued. And then at 112 and 113, he makes his findings, and if I could invite the bench's attention and ask that they read those paragraphs, please.
What's the answer?
The answer is they didn't accrue until a claim had been made up the line.
This is against in the background of him saying at 108 there's no particular points of law.
Exactly. Other than these. And another one, which is also quite difficult, but we don't need to worry about that. So he says, cause of action accrues when the client, when the main contractor makes the up the line claim, and he relies upon, as I indicated a moment or two ago, NI credit and safety. Now, in my respect for submission, this approach to this issue is entirely consistent with the authorities that we looked at this morning. Because when the when the employer makes the claim, that will be because damage has materialised to the building. And so one will not be in the slightly, in my respect for submission, surreal world that one finds oneself in if one adopts a co-op and burst analysis, which is that an employer who retains a main contractor and a nominated subcontractor may find that its claim against the nominated design subcontractor does not crystallise until the physical damage has occurred. So the main contractor seeking, making a claim in negligence against the design subcontractor is tied to a much earlier accrual date on the basis of co-op, namely the date when he hands the project back to the employer.
Much earlier than what? Sorry, I missed what you said.
I'm sorry, my lord, let me start.
That the claim against the subcontractor might crystallise much earlier, i.e. completion, than the claim...
The claim that the employer would have against that nominated subcontractor, employer building owner, on a Pirelli basis.
Except at that point didn't arise in co-op and burst because Pirelli wasn't even cited.
No, absolutely, my lord. But what I'm explaining, or trying to explain or submit, is that the co-op and burst analysis results in a situation where one has this oddity, which is claims which concern effectively the same damage with the building. We're talking about the same defect affecting the building, would crystallise at two different points in time, the employer building owner would not have a claim until damage was suffered. But the main contractor on a co-op and burst analysis would have the claim when it handed the building back to the employer building owner. And in my respectful submission, that's an odd state of affairs when one is effectively concerned with the consequences of the same defect.
So do you say that co-op and burst was wrongly decided?
I do, my lord, and I'm inviting this court to prefer the approach taken by Mr Justice Aikenhead in the Linklaters. But my lord, I also say that you don't have to go so far as to say co-op and burst is wrongly decided, because, as I said right at the beginning, I say we're in a different factual circumstances to co-op and burst. In co-op, there was no proprietary interest in the building, and claims were made. So we say all of the difficulties of trying to reconcile co-op with Pirelli are avoided if one goes down the Linklaters route. And finds the cause of action in relation to an exposure to a liability does not accrue until the claim has been made. Here, no claims have been made. And that is the end of the matter. The third way now in which BDW puts its cause of action case is that it's accrued a cause of action when it discovered the defects in 2019. And members of the court, you may remember this morning being taken to the relevant paragraph in the particulars at page 59 in the core bundle, in which BDW itself said at that point in time it incurred a financial loss in order to avoid reputational damage. We say that third way of putting the case, namely that the nature of the loss is to avoid reputational damage, simply cannot survive the decision of Mr Justice Fraser.
I don't quite understand that. I mean, he looked at reputational damage and decided to strike out little subparagraph 7, but he concluded the other subparagraphs 1 to 6 were not reputational damage.
He did,
and that's not appealed against.
He did, my lady, but what he also found, the reason that he struck out the
little 7 or whatever
little
it is.
7, whatever it is, 48.7, is because of his conclusion earlier on in his judgment that that URS owed no duty to BDW in relation to reputational loss. Now, my lady, he was only considering, having found that the cause of action in his view occurred much earlier on, he didn't go on to consider what the position would have been if he was in the world of his of Mr Hargreaves' tertiary case. But in my respectful submission, having concluded in terms that URS owed no duty to protect against reputational loss, if he had dismissed the first two ways that BDW put its cause of action case, and actually turned his mind to considering what is described in the judgment as the tertiary case, he would have concluded that the tertiary case could not survive his findings on scope of duty. I thought, my lady, I can certainly give you a couple of paragraphs in terms of the judgment references on reputational loss. These aren't the only ones, but essentially for your ladyship's note, it's paragraphs 43 and 62 of the learned judge's judgment.
Thank you.
Which is tab 12 of the core bundle at pages 150 and 154. I think there were a couple more, but so we say those findings dispose of the tertiary case.
Sorry, which findings?
The findings
I
about
want to be.
reputation.
You'll have. Very sorry. You'll have to show me which findings you say, in some way, dispose of the tertiary case.
So, my lord, maybe if we take it by just starting with the tertiary case, which is at page 59 of the core bundle.
I'm a bit lost. Core bundle.
I'm so sorry, my lady. Core bundle, tab 5. We're back in the pleadings. I'm going
Tab
to.
5 is.
Tab 5 is the respondent's notice.
Oh, I do apologise, my lord.
I'm just.
My lady, I have. Wait a minute. I've got myself into a mess. It's Supplemental Bundle Volume 1. I do apologise to the court.
Yep.
Supplemental Bundle Volume 1, tab 5.
Yeah, the bit that we showed
Yes,
this morning. Yeah.
Absolutely. That's the starting point. That's the tertiary case. In terms of the judgment, the findings in the judgment are in paragraphs 43, which at page is the core bundle tab 12, page 150.
Yeah.
And in fact, my lord, there's an entire section in this judgment which deals with it, but 43 to 47, and then back again at 62, which is at page 154.
Yeah.
Which is the judge's findings on the question of whether or not I owed, or my clients owed Mr. Hargreaves' clients a duty to protect against reputational loss on the scope of duty question.
Yeah.
The judge finds that we did not owe that duty.
Well, the judge didn't accept the characterisation. 45. You rejected your characterisation of all of the losses as constituting in reality damages or losses for harm to BDW's reputation.
But my lord,
And as my lady said, I don't understand paragraph 45 to be the subject of an appeal.
it isn't the subject of an
No,
appeal, my
fine.
lord. But my point is a slightly different one. One of the issues before Lord Justice Fraser was whether or not URS owed BDW a duty to protect against reputational loss. What the judge is doing in this part of his judgment is looking at the heads of loss and damage and noting that one of those heads of loss and damage is described as reputational loss. The other way in which reputational loss appears, my lord, is in the tertiary case, in which BDW says in terms, we incurred the money all of those heads of loss and damage for the purposes of avoiding reputational damage. The learned judge doesn't deal with that formulation of the case in those terms.
With respect, Miss Parkin, he does. I do not accept that consideration of the scope of duty in this or indeed any case requires analysis of the subjective views on the part of the claiming party.
My lord, that is in connection with the heads of loss and damage. So there are two elements of this of the BDW case. The first, in terms of when causes of action accrue, is set out in the reply, those 3 paragraphs. We've been through heads 1 and 2. We're now looking at head 3.
Yeah, no, I understand that.
And this has got nothing whatsoever to do with motivation for the purposes of why it is they incurred the losses. It is picking up on what they themselves plead as the nature of the loss that they incurred.
What they themselves plead as their motivation.
No, my lord, that's the point. This is a plea about when a cause of action accrued.
All right, well, I understand the point.
And one can see that, my lord, if one looks at the top of page 58, which says in terms BDW suffered damage and had an accrued cause of action. In any event, my lord, at the point in time that it incurred the losses, it had no proprietary interest in the building. It had sold that for full value. And it had not been exposed to any claims.
I mean, that's a thread that goes through all your arguments.
Absolutely,
We've taken
my
that
lady,
firmly on board.
It is. I'm obliged. I'm just sort of closing
And
the
that's
doors
why.
if I can.
And that's why you say that in fact there never was a cause of action.
Absolutely.
That's your primary point.
It is my primary.
Although you fairly said that, well, if there was a cause of action, it would have been when they discovered it for the reasons that you've been explaining. But you say, in fact, on these facts, they didn't accrue then because they'd sold it for full value.
Absolutely, my lord.
understand that.
They sold it for full value, and essentially they were not and never were exposed to claims. So asking oneself this question, what interest of BDWs was damaged at the point in time that they discovered the defects? In the sense in which the law has recognised to date interests which a designer owes a duty to protect his clients against. See the analysis in Stuart Smith in thus, and we say no such interest was damaged. Which is why, in that sense, my lord, round 1 of the appeal comes back into ground 2 on the tertiary case.
Thank you.
That is, well, I was about to say that that is the end of the appeal, the first appeal submissions. There is then the point about section 135 and what that means, but in the light of the observations from the court this afternoon, what I'm proposing to do is to come back to all of 135 at the end of everything, because as I said at the beginning of the afternoon, one is concerned exactly, and rather than do it lots of times, you might get slightly annoyed with me if I do that. I will do it once at the end. But for these purposes, suffice it to say that I say, if I am if the court is with me on the appeal, the result of that is that the entire claim gets struck out. And for these purposes, the court needs to bear in mind that the claim as originally postulated back in March 2020 included claims under the DPA and contribution, and the court can see that if it looks at the one of the many claim forms. Just bear with me a moment.
Ms. Parkin, just before we look at those, I think we saw those earlier, in fact, but I think we saw references to contribution and
yes,
DPA
but that's in the particulars of claim. I'm going to take your lordship to the claim form if you'll indulge
fine.
me.
Can I ask you a question just before we
Yes.
turn to that? Because I understand completely how you've put those submissions. I've just got a question which really comes out of ground one.
Yes.
Which has been nagging away at me over the last few days, and I just want to put it out in the open and see what it is I'm missing. In an ordinary case, a structural engineer owes his client a duty of care, and that will be to prevent loss arising from defects in the design. Ground one is really, in one sense, a timing point, isn't it?
Yes, my lord. Well,
But I just wondered how that worked in practice. You say, well, there was no duty to protect BDW once they'd sold the building for full value. So did the duty come to an end?
we say...
Did it change? I mean, it's a slightly surreal, to use your word earlier, it's a slightly surreal sort of scenario, isn't it?
No, my lord, I understand why your lordship says it's a timing point, and why I jumped in and sort of said yes, and then thought I would think better of it and explain that submission. It is a timing point in this sense. You'll remember right at the beginning of this morning, I took your lordship to the contract, and the bench to the contract, and I described and showed the court how, under this contract, what BDW was doing was setting itself up to get rid of everything and for URS to give others to whom it was disposing of its interests cover, if I can put it in those loose terms. We say that that means that it was not within the contemplation of these parties in 2003 that out with that cover there would be some sort of situation in which BDW would come back in, if I can put it like that.
Well, I'm glad I asked you. I'm not conscious of that point having arisen before.
That was the point that I was explaining to your lordship this morning. I hoped I was clearly not.
Well, you were showing us the contract, and I bit back saying, well, that's entirely standard for any developer. Any developer is usually proposing to sell it on once it's complete. Doesn't make this case any different.
No, it doesn't make this case any different.
So again, it would be what? That the duty expired? What happens to the duty that you accept was there as these towers were rising from the ground?
It depends what the duty is in relation to, my lord, and that's why I made the point in our submissions, and I took you to what Lord Mr. Justice Stuart Smith says in Pirelli. Sorry, in Co-op.
All right, well, imagine the duty, sorry to interrupt you, but I'm sure we can do it quite quickly. Imagine there's a duty to avoid defects which led to physical damage.
One has to ask oneself this question, which is the question which is asked in Murphy, which is, I understand that, but what is the physical damage being caused in those circumstances? It is damage to my economic interest in the property.
All right. So you accept that that duty existed
Yes.
in 2001.
Yes.
What happened to that duty?
When the property is sold for full value, the developer suffers no loss because it has achieved full value in relation to its proprietary interest.
And so you say nothing happens to the duty carries on, but it can, the requisite criteria
There is no loss.
can never come
Absolutely.
to pass.
Absolutely.
That's, the duty isn't affected, but it's never going to be triggered.
Absolutely. I mean, whether one calls it, in a sense, a duty or actionable loss, essentially, it doesn't.
The triggering circumstances are never going to come into effect,
Absolutely.
you say, once they've sold on.
Absolutely.
So it is a timing point.
Yes, that's why I said, in a sense,
Yeah.
yes.
Well, I got
and
that.
then
I tell you.
paused.
Sorry, I interrupted. My lady very kindly let me ask that question, so I'm glad I did. Thank you very much for your answer. You were showing us, you were telling us
Yes,
that if you were right on the appeal, then the claim should be struck out.
Yes, and I was just going to show you what the claim which was instituted was. We looked this morning at the claim, at the particulars of claim, just for the court's reference before we move on to deal with the amendments. I'm in the core bundle now, tab 21. This claim form has in fact already been before my Lord Justice Coulson before in December 2021 when he sat with two other members of the court on a striking out of a claimant, a defendant on a name change point.
Yes, but that's not in the authorities bundle.
No, it isn't, my Lord. I'm just
I was
reminding
deeply hurt.
We can rectify that overnight, my Lord.
No, don't trouble. Okay, so this is that claim.
This is that claim form,
Yeah.
my Lord. The only reason for drawing the court's attention to it right now is at page 204. And it doesn't matter for these purposes whether we look at the black, the red or the green. All of this happened in March 2020. The claimant's claim is for damages for breach of contract, breach of duty, for the avoidance of doubt, whether in tort, at common law or under the Defective Premises Act 1972, in respect of the first defendant's design and consultancy. And then over the page, so we have there effectively breaches of DPA, contract, tort, and then over the page at paragraph 205, the claims for contribution 1Cs at paragraph 7. Set up in the earlier paragraphs 5 and 6. And so that was the reason, because those claims were there on that claim form, that was the reason when the amendments came to be made last June, that there was no need to go back and re-amend that claim form because they were sitting there from the beginning. Now, I said I was just going to close off the ground one of the appeal, and then we got diverted into timing. Ground one of the appeal, we say, if the court is with us on ground one of the appeal, section 1356 of the Building Safety Act means that that is the end of the matter, if I can put it in those terms. The reason for that is that the court will have determined that Mr. Justice Fraser got the answers wrong, and we will say, as a result of that, the claim which is advertised in this claim form and in the particulars of claim gets struck out. And the result of that is that 1356 of the Building Safety Act, which talks about a claim being finally determined, comes into play and means that's the end of the matter. We've got, obviously, I have to develop some submissions on what 1356 means, and in particular what claim means in that context, and finally determined, but I will do that when I pick up Building Safety Act right at the end. But just sort of for bookmarking purposes, that's where that argument fits in the scheme of my argument. Moving on then to the appeals from the decision of Mr. Williamson, King's Counsel, sitting as a Deputy Judge in the High Court in November and December last year. As the bench will have seen, we say that the learned judge either got the test for making applications to amend wrong, or if he got it right, he misapplied it. In particular, in relation to his application of the test about short points of law and whether they should be determined on an application for permission to amend. There is unsurprisingly a bit of authority about that. One of the judgments being a case in which my Lady Justice Asplin gave a judgment for the sake of speed, and because I think the principles are well known to the bench. I'm just going to say what the cases are and say they support the proposition, which is if there is a short point of law, it can and should be determined on an application to amend, and that the judge should grasp the nettle. And the case is Easy Air, which is in your authorities bundle at tab B1. These are the big authorities bundle.
Sorry, tab
B1, Easy Air. B2, Elite, being the decision in which Lady Justice Asplin gave the leading judgment. B6, Kawasaki Kissen, being a recent decision of the Court of Appeal on short points of law.
That was in
2018.
no. B.
So sorry, my lord. My name is B6. B6.
Thank you.
And finally, phones for you, first instance decision, which you'll find in B5. Now, those cases all repeat the short point of law test. And as I say, in a sense, I mean, it's a test which is a bit like an elephant, in that when one, it's easy to describe, but the application of it may be slightly more difficult. Just by way of, I don't intend to detain the court on these authorities very much, but just to give you a flavour of the sorts of issues which the court has been prepared to determine as short points of law. Easy Air concerned a case of construction of a sale and purchase agreement. A claim for breach of fiduciary duty, and equitable claims for accounts and inquiries.
Gosh, that doesn't sound like a short point of law.
Well, that was the judgment of Mr. Justice Lewison, who obviously was not deterred.
You should have told us that.
Elite Properties, which my
Can
note
you give
says...
us some from somebody else?
Yes, exactly. This is what my note says. Judgment of Asplin LJ, appeal from Waxman decision to refuse leave for amendments. Application to add a claim in the tort of an unlawful means conspiracy. And then there were all sorts of issues about whether or not that claim had been settled or compromised by previous releases. and were fundamental elements of the tort missing from the draft pleading before the court. Lady Justice Asplin decided that she was not deterred and was prepared to grapple with that one. Kawasaki Coulson is not an amendment case, but it is a service out of the jurisdiction case when the same test applies. That was an appeal from Mr. Justice Tier in the Commercial Court, and the main judgment is given by Lord Justice Popplewell. That concerned an application to add a claim for knowingly and intentionally, to serve out a claim in relation to knowingly and intentionally inducing a breach of contract. And the court considered the elements of that notoriously difficult claim and whether they were established on the evidence. It also did so against the background in which I think the appellant had turned up with a new formulation of its pleading, effectively at the foot of the door of the court. Anyway, the court was not deterred by any of that and proceeded to determine those. And Phones for You is a judgment of Mr. Justice Roth, which concerned the very unusual case in which a private party was pursuing claims in relation to anti-competitive collusion. Those being claims which are normally advanced by a competition authority as opposed to private individuals. The courts were prepared to grapple with those sorts of cases in order to determine the summary applications which were before them in those claims. In my respectful submission, questions in relation to the construction of the Defective Premises Act and in relation to the construction of the Contribution Act are claims which are easily disposable by way of determination of short points of law. And I would make this further point, which is that these are not points which require any detailed investigation of the factual background. They are, however, points which require consideration of statutes. And that is the task with which this court, and indeed Mr. Williamson, King's Counsel, sitting as a Deputy High Court Judge, are well able to deal with. So, unless I can assist the court on the test anymore, I'm proposing to go straight into the substantive applications themselves.
So the test point is effectively you say he should have grappled with
Yes,
underlying points in relation to the DPA
yes,
and the CLC.
yes, we should have seized that nettle.
Yep.
And I'm inviting this court to seize it now instead.
So you're going to go on now to proffer the nettle.
I am, my lord. I shall do so with kid gloves. We're going to start with the Defective Premises Act claim. As I showed the court a moment or two ago, that was a claim which was included in the claim form at the outset, but it was not pursued in the original particulars of claim. Presumably, for the reason which Mr. Hargreaves gave in relation to his Contribution Act claim not being pursued, which was at the time these proceedings were instituted, back in March 2020, the Defective Premises Act claim was recognised, whatever it was, as being well and truly dead in the water.
Because of limitation.
because of limitation.
As a matter of interest, when does the cause of action accrue in relation to the Defective Premises Act?
It accrues on practical completion of the building. And it runs, and under the old Act, as I know your Lordship will know, it had a 6-year limitation period by virtue of Section 9 of the Limitation Act, which applies to all statutory claims, apart from Contribution Act claims. So, not pursuing the original particulars of the claim, Building Safety Act comes into force, an application is made to add the claim, which, unless the court is particularly concerned to see, I'm hoping you can take as read, it was essentially an application by which the duty was pleaded out, the breach of the duty was added to the negligent breaches, and the loss and the damage was said to accrue as part of the Defective Premises Act claim. There are no other changes to the claim in terms of no other additional allegations of, what I might call them, breach added. So it's effectively the claim that was before, but with the Defective Premises Act angle added at the end. We objected on 3 grounds. Firstly, we say BDW, as a developer, is not a person to whom a duty is owed under the statute. Secondly, we say BDW did not suffer any relevant loss because this statute is a statute which compensates those with a proprietary interest in a building. It's about fitness for habitation of the dwellings, and that is not BDW. And finally, we say that BDW could not rely on an extended limitation period under Section 135. That's a separate point from my 1356 point. And we say that because we say these are existing proceedings. And where the court is concerned with existing proceedings, very, very strict rules apply in terms of retrospectivity, which we will go on to explain to the court at some stage. But essentially, that is the landscape of the DPA amendments. Mr. Justice, sorry, the Deputy Judge allowed the amendments on the basis that he said that BDW's case was reasonably arguable and that these were not short points amenable to summary determination. And the reference for the court's note is the core bundle, tab 14, pages 179 to 180. They're very, very short judgments, and essentially the court will see. I don't know whether the court's had an opportunity to consider those judgments.
Yes.
Unless it would be of assistance, I'm not planning to go there. You can see that they say what they say. Let's look at the DPA. The starting point in our respectful submission is that the DPA, when enacted, was regarded as a piece of consumer protection legislation. And you may recall this morning I showed the court those extracts from Murphy and Brentwood, in which the judges describe the DPA in terms as a piece of consumer protection legislation. Those passages were cited recently in a Court of Appeal decision called Heronsley, which is, I think, in the core bundle, and we'll come to look at probably later on today. Heronsley repeating the point about this being a piece of consumer protection legislation. The fact that the DPA is a piece of consumer protection legislation, we say, can be seen from the Law Commission report, which we'll go on to look at in a moment, because we do say that the Law Commission report is an important aid to the construction of this statute, and indeed it is a report which firstly has been regularly cited in pretty much every case on the DPA that one considers, and we would invite the court to do so here.
Although we have to bear in mind that a lot of academics have pointed out over the years that the DPA fell far short of the Law Commission's expectations for various reasons.
Well,
And indeed, until the BSA, it's never been an act that's had particular traction.
and the reason for that, my lord, it would appear, is probably to do with the limitation provisions, because I think, as your lordship will be well aware, the DPA itself was enacted almost word for word in terms of the Law Commission's recommendations. How it might have been interpreted subsequently, obviously a matter for the courts and not for the Law Commission.
Yes, but certainly speaking for myself, I think you might well be right that as a result of the limitation point, it has not been at the forefront. It is clearly a piece of consumer protection legislation, but it doesn't look as if it's a piece of legislation that consumers have rushed to protect themselves with.
Well, I mean,
They will now, of course.
Yeah, well, indeed. As your lordship is about to be, I suspect, inundated. But one of the other reasons which we say this is a piece of consumer protection legislation, and by consumers, I'm talking about lay consumers as opposed to industry consumers, if I can put them in those terms. One of the other reasons why we say it's clear that this is a piece of legislation designed to protect, in the olden days I would have said the man on the Clapham omnibus, but I may say something different now, but designed to protect the individuals, is apparent from looking at section 6 of the DPA itself, which we'll come on to do in a minute. Right, with the court's permission, I'd like to start at the beginning by looking at the Law Commission reports.
I'm not trying to deter you from doing it, but I don't see that the Law Commission report is hugely helpful to us as a matter of when we're trying to construe the DPA. But there we go.
Well, I'm grateful for that observation, Lady Justice Asplin. What I'm going to start to do then is I'll go straight to the statute and essentially, should I need to
Absolutely.
return to the Law Commission report, may I reserve my right to do so? As I've already indicated, the Law Commission report, let me start again. The DPA, as enacted, which the court will find in the second supplement authorities bundle at tab
C1.
C1, I'm obliged.
I'm sorry, so what am I looking for?
You're looking for the second joint authorities bundle, my lady.
Yep.
Right at the back are the relevant statutes. C1.
Yep. Thank you.
Just so your ladyship knows, the Law Commission report is right before it.
Yes.
Title: An Act to impose duties in connection with the provision of dwellings, and otherwise to amend the law of England and Wales as to liability for injury or damage caused to persons through defects in the state of premises. Duty to build dwellings properly. The paragraphs on which I'm going to place particular reference, my lady, as you've probably picked up from my submissions, are paragraph 1.1a, which is the paragraph which BDW seeks to bring itself under, and paragraph 1.4, which provides for developers to be persons who take on work. In my respectful submission, a developer cannot be a person who takes on work in connection with the provision of a dwelling house, and B, a person to whom the dwelling house is provided to the order of. I say that's clear as a matter of statutory interpretation. But at the risk of incurring the wrath of one part of the bench, I would say that if there is any lack of clarity in that regard, what is meant by section 1.1a is to be divined from delving into the Law Commission report to ascertain the mischief that this provision was aimed at protecting against.
Well, give us the reference without turning it up and we'll read it.
I'm pretty sure I've got the references in my skeleton,
Oh, fine.
my lady, but if I can...
No, that's fine. If they're in your skeleton, we'll go back to that. Thank you.
I'm obliged, thank you. So we say that it is obvious from that very simple and short point of construction that BDW is a person taking on work for or in connection with the provision of a dwelling.
I'm sorry, leaving aside the Law Commission report, what's the point of construction?
Effectively, my lord, that you cannot be a person who provides the dwelling and a person to whom the dwelling is provided.
Why not?
Because one is building it to provide it to somebody else and one is having it provided to them.
Just like a contractual chain.
Well, my lord, yes, but the difference is here that BDW is not having a dwelling. There is no contract between URS and BDW for the provision of a dwelling, which is what we say 1.1a is aimed at.
But URS were providing a dwelling to the order of BDW.
Exactly. Well,
So
sorry,
they're-
no, stop,
so-
they weren't, my lord, they weren't. They weren't.
I thought you showed us the contract this morning.
That's not a contract for the provision of a dwelling, my lord. It is a contract for the provision of structural services in connection with a development.
Yes.
And furthermore, as I showed you when we went through the pleadings in relation
So that's
to...
work in connection with.
It is, my lord. I'm not suggesting that URS does not owe a duty under the DPA to those...
I thought you were.
No.
I mean, I thought that's where you were going now.
Well, yes. I'm not suggesting that...
Unexpectedly, I have to say, but
yes, one of my more remarkable submissions.
yes, I was
I'm not
slightly
suggesting
taken
that
aback.
URS does not owe a duty under the Defective Premises Act.
All right.
I accept that URS owes a duty under the Defective Premises Act. I do not accept that it owes a duty to BDW under the Defective Premises Act.
But BDW would be the order of any person. BDW would be that person.
No, my lord, for this reason, BDW has not ordered URS to provide it with a dwelling. And that, in my respectful submission, is the construction which is intended and can be seen from the Law Commission report. So this is about people, individuals, who ask a builder to build them a house. That is not this case.
So a housing association
It's not a
wouldn't be
development,
called.
my lord.
It wouldn't be. That's not an individual. You said this is about individuals.
It is. Sorry, my lord. I'm not making myself very clear. I accept that a housing association, if it commissions a builder to build it a series of houses, would be owed a duty under the DPA.
So I don't get the difference between a housing
Because
association and a developer.
Because the housing association is in the business of effectively running a series of houses. That is not the issue here. BDW is effectively identifying, essentially it's involved in the provision of buildings for commercial sale, for a profit.
So we've got to read 1(1)(a) as if it said owes a duty if the dwelling is provided to the order of any person who orders it for the purposes of a dwelling.
No, my lady,
Something
no.
like that.
No, I'm not saying that.
Okay.
What I'm saying is that URS is not providing a dwelling to BDW. I accept that it is carrying out work in connection with the provision of the dwelling.
Yes.
But as is clear from the Law Commission report, 1(1)(a) is about a contract to provide the dwelling. That is not what this contract was about. And my lady, in our respectful submission, if one turns over right to the end of the Act and looks at paragraph 6 supplemental, we see at paragraph 6(3) this provision. Any term or agreement of an agreement which purports to exclude or restrict or has the effect of excluding or restricting the operation of any of the provisions of this Act or any liability arising by virtue of any such provision shall be void.
And you say that helps us to construe section 1(1) to mean that it's got to do with a contract.
I say that, my lady, for these reasons. In contracts between developers and professionals, there are frequently limitation of liability clauses in terms of the amount of money that the professional would be liable to the developer for. And often limitation of time clauses in terms of the extent of the professional's length of exposure, and sometimes net contribution clauses which provide for the netting off of liability where a professional is one of many members of a professional team. If the provisions of section 1(1) were construed such that URS or any professional member of a development team owed a developer a duty under the Defective Premises Act, all of those exclusion and limitation of liability clauses that one commonly and regularly sees would go. And I say this as well, if that were indeed what parties had understood this Act to provide for, it is, in my respectful submission, surprising that we haven't seen Defective Premises Act claims in addition to breach of contract claims, because if developers could bring themselves within DPA provisions, it would mean that they could walk away from their contractual limitations of liability under the contracts of employment which are frequently in place. So I do place some emphasis on that clause and on the fact that in the almost 50 years, in fact more than 50 years, since this statute has been in operation, no developer has sought to avail itself of the opportunity to skip away from those frequently negotiated limitations of liability clauses.
I completely understand the first point. It might be fairly said that the answer to the second point goes back to what we were discussing earlier, namely that the Defective Premises Act has been not been top of anybody's litigation list. First point I completely understand, but the second point,
Well,
it's a point. But
it is a point, and it's a point that Lord Justice Hamlin in the Heronsley case, which we'll come to look at in a moment, placed some significance on, because in that case he was being asked to find that the DPA extended to requiring local authorities to owe a duty under the DPA, back to Anne's, and he concluded he wasn't prepared to go that far. He relied on Murphy as the consumer protection legislation point, and he also said he regarded it as significant, but nobody had thought to run that sort of argument before it was run in the Court of Appeal, noting that with all the clever lawyers in the world, one might have thought that someone might have come up with that point before. I make the same point now to the bench.
Yeah.
Now, of course, the court is capable of giving effect to the parties' contractual relationships in terms of limitations of liability clauses, etc., if it is faced with a contribution claim under the defective, so it was founded on the basis of a Defective Premises Act claim. So, assuming that a developer is exposed to a Defective Premises Act claim by the residents of the building, the developer can then join all of the members of the professional team for a claim in contribution, all of them being liable to the homeowners under section 11A of the Defective Premises Act, at which stage the court, because it has the power under the Contribution Act to order such contribution as it thinks is equitable and just, can in those circumstances give effect to the contractual relationships negotiated between developer and professional team. So to come back to the point which my Lady Justice King expressed a degree of surprise about a moment or two ago, I'm not saying that there is never any potential for a DPA claim against URS. I am saying that in these circumstances such a claim does not lie. So that's the statutory interpretation point. The next point is what the loss and damage attaching to a DPA claim is designed to compensate against. In my respectful submission, it's clear that what it is compensating is the owner of the building at the time when the claim arises. And the matter can be tested like this. If a building changes hands, it's bought by the first purchaser, it's sold by the first purchaser to the second purchaser, and it's sold by the second purchaser to the third purchaser, and ask oneself, do all of those purchasers have a potential claim under the DPA? The answer in my respectful submission is no, they don't. Only the person who is in occupation, i.e. who has the current legal or equitable interest in the building, has the right to bring a Defective Premises Act claim, or the right to be compensated by an award of damages under a Defective Premises Act claim, because what you're compensating for is the fact that the premises is not fit for habitation.
And where'd you get that in the statute?
I don't get that from the statute, my lady.
I just wondered whether the closest you might come to it is section 3, subsection 1, where work of construction, repair, maintenance or demolition or any other work is done on or in relation to premises, any duty of care owed because of the doing of the work to persons who might reasonably be expected to be affected by defects. And I wondered whether you were relying perhaps on that phrase.
Well, the reason that I'm not relying on that expressly, although I'm grateful for the indication,
I'm not.
is that Section 3 is normally thought to apply in a slightly different circumstance to the one that we are currently.
But
I
I can't
understand,
find
yes.
any words that come close to
my lord.
assisting you
No,
otherwise.
No, my lady, and I'm not. What I'm submitting to the court is when one thinks about what the purpose of an award of damages under this statute would be. What is it that the statute is trying to compensate? And in my respectful submission, it's trying to compensate the current owners of the property for the fact that they have a property which is not fit for habitation.
It's quite a curious little statute, isn't it? And I'm sure that everyone else in this room knows a great deal more about it than I do, but I find it very curious. And as I say, I'm not terribly content or happy with trying to construe it against the background of the Law Commission. I'm not suggesting necessarily that this is a case in which a Hansard would be admissible. But has anyone looked to see what it says?
The Hansard extracts are in the bundle.
Yeah.
And the Hansard extracts, and again, I'm not necessarily suggesting either that it's appropriate to go to Hansard, but so that your ladyship knows, they are in the bundle and they commend, I'm afraid to say we're back to the Law Commission report, but they commend the Law Commission report and the draft bill published and attached to the Law Commission report to the House, and commend the House adopting.
Thank you. Well, that's a better route back to the Law Commission. So could you give me the references for
I can, my lady. Can you
or
just,
somebody can later. Don't worry, I don't want to hold
probably
you
do
up
this
now.
right now. There are bundles, as your ladyship will have seen, there are bundles for each of our little topics, so to speak. And having said that, I can see it's not in there. Here we go, my lady. It's in fact bundle F.
Yes.
And the relevant tabs are 4 and 5.
Thank you.
Hansard debate on Defective Premises Act, February 1972 and May 1972. And I think, I say that your ladyship knows the relevant, the debates are, it's by the relevant proposer of the Act. So it's the relevant person speaking is what I'm trying to say.
It says need to sidestepping pepper and heart.
Yes. Which I had not intended to get into.
No,
No.
presume not.
Or certainly not this afternoon.
I don't think it's necessary.
I'm obliged.
And I'm see why we want the thread, but I really think that we're not going.
I'm not intending to, and I am.
I'm not suggesting it either. I just wondered how we got back to the Law Commission.
And that is how we get back to the Law Commission. And there is no dispute, my lady, that the Law Commission reported, and I'm going to tempt fate and suggest that your ladyship looks back into bundle B, this core bundle, back into tab B1. And your ladyship will note that the title of the report is Civil Liability of Vendors and Lessors for Defective Premises. Now I say that to highlight the fact that, as the bench will be aware, BDW is neither a vendor or a lessor of the premises. And if your ladyship would be good enough to turn on to page 1.
Neither a URS.
I beg your pardon, my lord.
Neither a URS.
No, absolutely.
So
absolutely.
We've started badly. The title of the
No,
Law Commission report bears no relation
No,
to the
but my
Act
lord.
actually passed,
My lord. In a minute, we'll
which
go
is
on.
my experience of the Law Commission, I have to say. There it is. Okay, so what are we looking at next?
I don't quite know what to say to that, my lord.
I just moved to page
I
1.
should
if
just
I
move
was
to
you.
page 1. Yes, thank you.
All right.
This is the introduction And if I could just invite the court to read paragraphs 1 and 2, the court will appreciate what it is that the Law Commission was designed, the mischief that the Law Commission had tasked itself with investigating. And then over on to page 2, paragraph 7 again repeats that same general theme.
Yes.
Questions for consideration, paragraph 9. And then section B, liability and contract defects of quality. This is the area of law which the Law Commission is the most concerned about in terms of its exposure, or the exposure of those who purchase houses, who purchase new houses, because effectively of the ability for builders who have been contracted to provide a house to exclude the usual implication of terms. One sees that from paragraph 13. And the rule of caveat emptor, when there is no contract between a builder and the purchaser, but what is happening is that the purchaser is buying a new house off a developer.
Yes.
And those twin problems, the problems imposed by the law of contract, when there is a contract to build a house, and the law of sale and purchase of houses when one is simply selling a house where there is no underlying contract between builder and purchaser to build that house. Effectively, one goes to a developer's office and buys off plan, so to speak. Those are the problems that this report is addressing, and its recommendations are designed to address those problems.
Well, we can see the recommendations at page 8.
I'm obliged, my lady. We've identified in our submissions, the relevant paragraphs which we place particular reliance on. I'm not going to take you to those, but you've got them in the note. But just to close off the point about the Defective Premises Act bill as appended to the report, one can see that at page 28. And if the court would let me say, having done the comparison, it is that there are a few sections which get moved around or renumbered, but in terms of the wording, the Defective Premises Act as enacted is by and large word for word identical to the draft attached to this report.
Now, does that bring you to the end of the DPA?
It does, my lady.
All right, so would that be a convenient
It would,
note?
my lady.
Now, where have we got to?
I think, so tomorrow we've got the Contribution Act, which is a short point, as I indicated, about claims. And then we've got retrospectivity, which I'm going to endeavour overnight to try to to shortcut it, so to speak. I'm hoping, with a fair wind and subject to questions, to be through within the first hour of tomorrow morning.
Thank you. Excellent. Well, thank you very much indeed. And I'm sorry it's still absolutely boiling in here, and I'll see whether something... I've kept fiddling with you, you've probably seen I've kept sort of optimistically turning the knob that's supposed to make a difference without any real hope. But I will see if something can be done. So my apologies to everybody. Very well. Thank you all very much. Last time, please.